For those of you who don't know me, my name is Annette Clark, and I'm the very proud dean and an even prouder alumna of Seattle University School of Law. We've been hard at work, particularly over the past year, in trying to create a better and a more effective anti-racism curriculum. And I want to highlight the work of Professor Paul Holland in helping us. He's the chair of our curriculum committee and so has been deeply engaged in this project. We're proud as a law school to say that we educate powerful advocates for justice. But sometimes we realize that we don't always know what a powerful advocate for justice looks like, or what that kind of lawyering entails. And so the program today is really the brainchild of Professor Holland. I know he was preparing to see the film Judas and the Black Messiah, which I've not had the chance to see yet. And what he discovered was that we have some of the really important players and lawyers in our region who were involved in the fight for justice for Fred Hampton and the Illinois Black Panther Party. So this is a story that comes to us from 1969. And so often the relevant history, particularly involving African Americans, Black individuals in our country, has been hidden from us, or we have not done a good enough job of educating ourselves. So part of our goal in our program today is really to remedy that. And we are so grateful not only for Professor Holland's efforts, but also the incredible speakers we have with us today, who Paul will introduce, but who are part of this living history. So with that, let me turn it over to Professor Holland to introduce our guests.
Great. Thank you very much, Dean Clark. You know, it was cases like this that made me want to be a lawyer. And so I'm awed, really, to be sharing this Zoom space with the lawyers who did and are still doing this amazing work. This being 2021, if you want to learn the full details about our speakers' backgrounds and accomplishments, you know, please go to Google, but put aside a bit of time. They've done so very much. I'm going to introduce them quite briefly out of respect for the story that they're here to tell and that you're here to listen to. Flint Taylor is a founding partner of the People's Law Office in Chicago and was one of the principal lawyers in the case that we'll be talking about today. As we tried to schedule a planning session for this program, Flint let us know that we'd need to work around some depositions that he was taking. So in other words, 49 years after filing the Hampton lawsuit, he's still in the fight, which says quite a lot about this nation and even more about Flint Taylor. And if after hearing him today, you want to learn more about his career, and I know that you will, you can buy his book, The Torture Machine, Racism and Police Violence in Chicago, which came out in paperback in November 2020. Holly Hill started working on the Hampton case when she joined the People's Law Office as a second-year law student. Within a couple of years, she was joining Flint in deposing officials from the FBI. Holly later became a public defender and then a judge here in Seattle. And she is living proof to the law students in the audience that the way to get involved in meaningful work is to show up and see where your guts and your smarts will take you. Bill Bender's career has touched about every sector of the legal profession. He was a federal defender here in Seattle before entering private practice. He is currently a mediator and an arbitrator, was a law professor for several years at Rutgers and for one semester here as an adjunct professor. As an attorney with the Center for Constitutional Rights, Bill played a pivotal role in helping the PLO navigate the uncharted waters of this litigation. About an hour after Bill had agreed to take part in this discussion, he sent the group a detailed outline. And when I say detailed, I mean, you would have thought that he was working from an open file that was sitting right there on his desk and not from 50 years of memory. It's just a remarkable testament to the power of the mind of an engaged lawyer. Our fourth panelist was not involved in the Hampton litigation, but I'm pretty sure the only reason for that is that she had not yet been born. If you look at what LaRon Baker is doing now, you can see how she is advancing the legacy of those who fought for justice in this case. As special counsel for affirmative litigation and policy at the King County Department of Public Defense and co-chair of the Seattle Community Police Commission, LaRon is here to show us all the ways and show us how you win the big battles by being ready and able to fight with whatever hand you can get free at the moment. There's enough material here for a 15-week seminar at least, but we plan to move through the events of the raid and the maze of the litigation in about an hour, with another 20 to 30 minutes devoted to some concluding reflections and questions from the audience. We intend to start, however, with some video showing you Fred Hampton himself. You will hear him speaking, some video clips that were aired on Democracy Now! A few years back. And as I cue these up, I just want to spotlight for those who aren't aware, as you're watching this, the fact that the really sort of astonishing and infuriating fact that Fred Hampton was merely 21 years old when he was murdered. So let me show you him. There we go.
This is some of Fred Hampton in his own words.
So we say,
Oh, sorry.
we always say in the Black Panther Party that they can do anything they want to us. We might not be back. I might be in jail. I might be anywhere. But when I leave, you can remember I said with the last words on my lips that I am a revolutionary. And you're going to have to keep on saying that. You're going to have to say that I am a proletarian. I am the people. A lot of people don't understand the Black Panther Party's relationship with white mother country radicals. A lot of people don't even understand that word that they're refusing to lie. What we're saying is that there are white people in the mother country that are for the same types of things that we are for stimulating revolution in the mother country. And we said that we will work with anybody and form coalition with anybody that has revolution on their mind. We're not a racist organization because we understand that racism is an excuse used for capitalism. And we know that racism is a byproduct of capitalism. Everything would be all right if everything was put back in the hands of the people. And we're going to have to put it back in the hands of the people. With no education, the people take this local foundation and start stealing money because they won't be really educated to why it's the people's thing anyway. You understand what I'm saying? With no education, you have neo-colonialism instead of colonialism like you got in Africa 9, like you got in Haiti. So what we're talking about is there has to be educational program. That's very important. As a matter of fact, it's so important for us that a person has to go through 6 weeks of our political education before he can consider himself a member of the party, able to even run down ideology for the party. Why? Because if they don't have an education, then they're nowhere. You dig what I'm saying? They're nowhere because they don't even know why they're doing what they're doing. You might get people caught up in the emotionalist movement. You understand me? You might get them caught up in because they're poor and they want something. And then if they're not educated, they want more. And before you know it, they'll be capitalists. And before you know it, we have Negro imperialists. We don't think you fight fire with fire fists. We think you fight fire with water fists. We're going to fight racism, not with racism, but we're going to fight with solidarity. We said we're not going to fight capitalism with black capitalism, but we're going to fight with socialism. We still said we're not going to fight reactionary pigs and reactionary state's attorneys like this and reactionary state's attorneys like Hammerhand with any other reactions on our part. We're going to fight their reactions where all those people are getting together and have an international 410 revolution. Black people need some peace. White people need some peace. And we are going to have to fight. We're going to have to struggle. We're going to have to struggle relentlessly to bring about some peace because the people that we're asking for peace, they're a bunch of megalomaniac warmongers and they don't even understand what peace means. And we've got to fight them. We've got to struggle with them to make them understand what peace means. Bobby Seale is going through all types of physical and mental torture. But that's all right because we said even before this happened, and we're going to say it after this, and after I'm locked up, and after everybody's locked up, that you can jail a revolutionary, but you can't jail a revolution. You might run a liberator like Aaron Cleave out the country, but you can't run liberation out the country. You might murder a freedom fighter like Bobby Hutton, but you can't murder freedom fighting. And if you do, you come up with answers that don't answer, explanations that don't explain. You come up with conclusions that don't conclude. And you come up with people that you thought should be acting like pigs, that's acting like people and moving on pigs. And that's what we've got to do. So we're going to see about Bobby, regardless of what these people think we should do. Because school is not important and work is not important. Nothing's more important than stopping fascism because fascism will stop us all.
The words of.
All right. So Flint, if you could maybe bring us back and introduce us to what the PLO was, how did it come about, and what was its relationship with Fred Hampton, the Panther Party, and the community as a whole.
Paul, I want to thank you for asking me to be on the panel with these wonderful folks that we shared so many memories and so much of the struggle with over the years. I was about Fred Hampton's age at the time of the murder of Fred Hampton. I, like many of the people listening today, was a law student. But in 1969, they were very turbulent times. And I was working with lawyers who wanted to make a difference, who wanted to represent those in struggle. And to do so, they and me working with them and other law students working with them started to represent Fred Hampton and the Black Panther Party. And we, in August of 1969, started the People's Law Office, in large part to represent Fred Hampton and the Black Panthers, to represent the Young Lords, and to represent other radical and revolutionary organizations that were in struggle and getting repressed and arrested and shot in Chicago. And that piece, 50 years later, every time I see it, still moves me. And Fred Hampton, knowing Fred Hampton, representing Fred Hampton, representing his family, was something that stamped us and has kept us moving forward in the struggle ever since.
Right. And Holly, then, how did you get involved?
Hi, can you hear me?
Yes, we can. But you
Are you getting feedback?
Yes.
Okay, I'm sorry. My computer just crashed and I'm trying to do this. I'm so sorry. Okay, can you hear me now?
Yes.
All right. Okay. I'm on my phone. Yes, I'm Holly Hill. I joined the law office for probably much more naive reasons than Flint did. I started law school at the age of 21 at Northwestern Law School and was shocked the first day to see that most of my classmates were dressed in three-piece suits, which I had not seen on anyone my age for several years. And I quickly determined that the law school was quite oriented toward careers in big law firms, silk stocking law firms. I had gone to law school because I just wanted to help poor people. I didn't know much more than that. I was pretty naive. I got involved first year working on a clemency petition for a prisoner, and I got involved in sort of carrying briefcases for a lawyer in a big firm who was representing a prisoner from one of the state penitentiaries involved in a prison riot. And so the spark was sort of lit, and I ventured over to a meeting of the National Lawyers Guild and ran into the People's Law Office folks. And then there I kind of found my home while in law school and after law school for 3 years before moving to Seattle, and was motivated and inspired by the work that they were already doing in Chicago and nationally for justice.
Great. Thank you, Holly. Very glad to hear. So now, Bill, Flint referred to the turbulent times of this year, and you're going to, I believe, hold on if I switch this up, just provide for a reminder for some and maybe an orientation for others as to just what was happening in America in the months leading up to this raid.
So thank you, Paul. So here are the 1960s in 2 minutes. I think to understand the impact of Fred Hampton and the party, context matters a lot. I mean, these were times of increasing social and political unrest and conflict. After years of frank racial discrimination in the northern cities, in housing, employment, education, public accommodations, many of those cities were experiencing outright rebellion, and Chicago was no exception. You know, it was if the festering boil of frank discrimination had finally burst open. Certainly the assassination of Martin Luther King, followed by the Robert Kennedy assassination in June, added to those tensions and unrest. And the brief experiments with the programs of the so-called Great Society were coming to an end. the great hope of the 1964 and 1965 Civil Rights Acts were not transformative of the ills that the society was experiencing. And not surprisingly, the civil rights movement was increasingly responding to calls for Black power. So the country was in political turmoil. And overlaying all of that was the turmoil around the Vietnam War. In April, 21 Panthers were indicted in New York City in a massive criminal conspiracy case. And although there were voices of reason calling for a massive political and social reset, in many places of power, people were acting repressively, and increasingly so as the calls for Black power increased. In Chicago, there was the uprising surrounding the Democratic National Convention in August in 1968. And then came Richard Nixon, who was sworn in January of '69. And his agenda, shared with his closest allies, was don't let them do to me what they did to LBJ. LBJ's career, of course, ending with the results of those turbulent times. So it was in this context that Hoover, director of the FBI, described the emerging Black Panther Party as the greatest threat to the internal security of the country. So this was the context for law enforcement's war on the party. And Fred Hampton's remarkable rise as a leader and an organizer in the face of these pressures was seen as an existential threat. And his success and his promise probably cost him his life. So there are the 1960s in 2 minutes.
Thank you, Bill. And that then brings us to December 4, 1969, the early morning hours when more than a dozen officers from the Chicago Police Department, acting at the direction of the Cook County State's Attorney, stormed the apartment where Fred Hampton and Deborah Johnson were in their bedroom with several other members of the party present, including Mark Clark, a leader of the party from Peoria, Illinois, who had come in to engage with the Chicago leaders. And that raid then resulted in the tragedy that our speakers will continue to describe. I have 2 images that we'll show you, and then ask Flint to talk about both finding out about this event and what it was that you learned as you got involved.
Well, like so many others in the People's Law Office, we heard that our client and friend Fred Hampton had been murdered early in the morning of December 4th. Skip Andrew, who was one of the lawyers involved in the case, did a marvelous job of organizing all of us, not only at the People's Law Office, but a film crew, photographers, and getting the Center for Constitutional Rights and, of course, the Rutgers Law School Center and Bill Bender involved at a very early stage and after the murder. I was called and told, come to the crib, the chairman has been murdered. So I headed to the law school where my friend and fellow law student working in the office, Jack Welch, was. I pulled him out of class and we headed to the apartment. It was a small apartment on the west side of Chicago. And when we walked in, of course, it was shock hit us, blood, bullet holes. It was, as soon as we were able to gather our thoughts and our emotions, we understood it was a crime scene, and that the lies that the state's attorney Hanrahan and the police had already put on the front pages of all 4 of Chicago papers, that it was a shootout, was a bold-faced lie. So as a law student, I spent the next 2 weeks in that apartment each day, taking evidence, documenting evidence, while the Panthers led tours of the apartment, brought people from the community through the apartment each day to see what really happened. And of course, I think there's the bed, there's the tour. people going in every day. And during that 2 weeks, many people came through, perhaps thousands. And one older African-American lady summed it up within earshot of myself during that time. She looked at the walls and she looked at the bloody bed, which the Panthers each morning brought up from a secret hiding place where they kept it during the night before. And she shook her head and she said, ain't nothing but a northern lynching. And I think that really stuck in my mind, as well as that crime scene and working in it for 2 weeks.
Bill, how is it that you became involved? How did you hear about this, and what did you do upon learning about it?
I was called by Arthur Kanoy, who was one of the founders of the Center for Constitutional Rights. I believe it was in the morning of the raid. Flint and I are kind of probing our historical memories here. Maybe it was the next day, but it was very shortly after the raid occurred. I was at that point one of the few staff attorneys at CCR, and I was just about exactly 1 year out of law school. Arthur asked me to go to Chicago, which I immediately did, and I was instructed to go to the scene, which I did, and met for the first time Skip Andrew and his other colleagues from the PLO. You need to understand that this was a highly unusual circumstance. I mean, usually the police, after an event like this, will take control of the crime scene, and nobody gets anywhere near it. Probably because of a fear of a community uprising, the police, after turning the apartment upside down, abruptly left. So we were faced with an open and an available crime scene. Somehow, Skip Andrew of the PLO had the wisdom and the foresight to approach that scene with a meticulous forensic approach. He gathered up the necessary materials for processing the evidence. He had Mike Ray of a local film crew with him, photographing everything he touched. He took meticulous notes and with great care had begun kind of processing what was ultimately to be the linchpin of telling this story. With the help of some of the Panther lawyers in New York, we were able to contact a forensic investigator who met us a few days later, and he then kind of supervised the completion of the crime scene investigation.
And Bill, I'm going to flip over to Holly here, because I know, Holly, that the forensic side of this case became a big part of the work that you would be doing over the time that you spent working on it. So I wonder if you could share what that was like and where it led you.
Yes. I joined the team several years after Fred Hampton was murdered. And in looking back and answering in taking on the challenge of explaining the battle over the narrative, I kind of looked back and wondered what kind of hubris made the police, the prosecuting attorney of Chicago, and the FBI think that their conspiracy to murder this young rising star, Fred Hampton, would somehow go unnoticed and would not be revealed. At first, I put the question differently. How did they think they could get away with it? Then I realized in a way they did get away with it. Fred Hampton was murdered. The Black Panther Party is no more. And none of the participants in the raid were convicted of crimes, nor did any pay money out of their pockets for what they did on December 4th. But that's a discussion for another day. I just wanted to say that that our focus on systemic racism in our day and age is so important because of that. But the planning and the execution of the raid and the cover-up that ensued resulted from the hubris born of the history of racism and brutality in our country, and especially in Chicago and among the Chicago police, and an historic failure to bring the perpetrators of racist and brutal acts to justice. So with that background, the Chicago police who conducted the raid burst into the apartment where 9 young people were sleeping, and they fired approximately 90 rounds from a Thompson submachine gun, a sawed-off shotgun with a hair trigger, rifles, and handguns. They did not choose to bring a bullhorn to announce their presence or floodlights to put the raid in the light of day. Rather, they snuck up on the residents in the dark of night so that they could enter from the front and the back, encircling the occupants. We have on the screen a diagram of that apartment, which shows the living room to the left, the entryway on the left at the bottom, the first bedroom going to the right, and the second bedroom where Fred Hampton and his fiancee were sleeping at the time. And on the far right, the back door, and the police came in from both ends. After the raid, the police ransacked the apartment, as I think Flint mentioned, making evidence preservation very difficult, if not impossible. They cherry-picked items from the apartment, including weapons, but left behind ample physical evidence which would eventually belie their narrative of a shootout instigated by the Panthers. Imagine the police not bothering to secure a crime scene where 2 people had died. Bill mentioned how unprecedented and outrageous that was. Several hours after the raid, the state's attorney, Edward Hanrahan, held a grandstanding press conference flanked by some of the raiders and displayed some seized weapons. In that press conference, he described a vicious gun battle with the criminal Black Panthers. But the narrative began to shift almost simultaneously. Bobby Rush, now a U.S. congressman from Chicago and a friend of Fred Hampton's, called the People's Law Office lawyers as soon as he learned of the raid early on December 4th. And as you heard, the team of People's Law Office lawyers went directly to the apartment that had not been secured and began collecting the evidence. And Bill told you about how painstaking that collection of evidence was. This was, again, an extremely unusual circumstance for private lawyers to be able to take a fresh crime scene and gather evidence themselves, and they were up to the task, thank goodness. And simultaneously, the Black Panthers began spreading the word in the community and conducting the tours that you saw in the photograph a minute ago. Now, I saw that apartment years later, and I was struck by how small the place was. Hard to imagine 9 people sleeping in that small a space, and even harder to imagine the bloodbath that occurred there on the morning of December 4th. Now, the head of the African American Patrolmen's League, for example, said this was a political assassination. And those people who walked through the apartment saw the fresh bullet holes and the blood that told the true story that was obvious to the naked eye. Hanrahan, the politician that he was, saw the narrative shifting, and in his hubris, he granted an exclusive interview with the Chicago Tribune newspaper, complete with photographs purporting to show bullet holes in the apartment from Panthers firing on the police. These were later exposed by the rival newspaper, the Chicago Daily News, as nail heads and not bullet holes at all. So Hanrahan and his men choreographed a reenactment of the raid for television, complete with a mock-up of the walls and the doorways of the apartment. The problem with this ultimately was that the outtakes of that filming became public, and they showed the officers retaking scenes while they were getting their story straight, showing the lies they were trying to perpetrate on the public. But it was the scientific evidence that showed without a doubt that this was not a shootout at all, but was actually a shoot-in. It goes without saying that Hanrahan, the police, and the FBI and their cronies assumed the general public, or at least this is my belief, assumed the general public, and at least the white public, would believe whatever they said and would not believe the accounts of the survivors of the raid, which ended up being completely consistent with the forensic evidence. The People's Law Office had the wherewithal, as Flint mentioned, to bring in, within days of the raid, a private criminal investigator to analyze the scene, the bullet holes, the trajectory of shots, the blood spatters, and the like. This investigator took the living room door to his library and determined that the only shot that could possibly be attributed to the Panthers of the approximate 90 shots fired was at a trajectory from low to high into a top corner in the hallway, consistent with the survivor's story that Mark Clark, who was murdered in the raid, was sitting in a chair behind the door when the police burst through the door, causing him to fall backwards and causing his gun to go off inadvertently. So the preliminary conclusions of the Black Panther Party and the People's Law Office were that the raid was a massacre and that the police burst in with no regard for human life, and even worse, with the aim of neutralizing and murdering Fred Hampton. And this original forensic investigation was later confirmed by the unimpeachable analysis and report of an honest FBI firearms and ballistics examiner, who again painstakingly counted and measured every one of the bullet holes and matched spent shells and casings to the weapons seized and the police weapons, and determined once again that at most only one shot was fired from within the apartment and almost 90 were fired by the police, including 40 through the living room. Could we see the chart again, please?
Yes.
40 through the living room wall, through the first bedroom, through the living room wall, through the first bedroom where people were sleeping, and into the second bedroom where Fred Hampton was sleeping, and right toward the bed where he was slain.
Great. Thank you, Holly. So Flint and Bill, I forget which of you was going to speak on this, but one of the next important stages of this process was the coroner's inquest.
Let me just introduce this for Flint very briefly, and then I'm going to turn it over to him. I want to convey what these lawyers at the PLO were confronted with in the aftermath of this raid. They had 4 injured clients, and of course, Fred Hampton was dead. The survivors were all under criminal charges. The state's attorney was spinning out a barrage of misinformation to create a counter narrative. There was a federal grand jury, more about that later, whose agenda was at that time not really known. And they needed to respond on all these fronts. Coroner's inquest was not at their making or doing, but they were forced to respond in that context as well. So Flint, you want to pick it up from there and talk about how we approach the inquest?
Well, there was the coroner's inquest was an antiquated kind of process in Chicago where they basically picked 6 people off cronies of the politicians and made them into a jury, and then evidence was put on, and they would then find rubber stamp whatever they were told the cause of death was. And so the fix was in, obviously, in the coroner's inquest that they were going to find it a justifiable homicide no matter what we did. However, we seized on the public spotlight to cross-examine all of the officers, bring out the contradictions in their stories, and Skip Andrew produced to the media the door panel, which showed the bullet holes. And they had told many different lies, but one of them was that there was only one bullet hole in the front door, and that was showing the Panther shot going out. And so it was a very remarkable denouement when Skip showed to all of the media the fact that the door panel had 2 holes in it. And that kept the controversy going. And then, since the Panthers had been charged with attempted murder and indicted by Hanrahan, ultimately they got out. And so the Panthers staged what was called a people's inquest. And they, in March of 1970, held the people's inquest, and all the Panthers, save one of them who had survived, testified. And they told their stories firsthand, primarily to the community, but also to the media. And you have to understand that this was an unbelievable media event or events, that there were 4 papers, all the TV coverage was every day for months on end. And this battle for the narrative continued during that entire period of time. And after the March People's Inquest, this federal grand jury, which we later understood was basically designed to cover up the FBI's role in the conspiracy, decided, despite the 90 bullet holes and all going and attributed to the cops, that they would not indict any of the police officers. So that happened in May of 1970. Now, during this period of time, we are dealing with all these different aspects, including the indictments, which were dropped against the Panthers because it was shown that they had falsified ballistics evidence to show that shells that they said came from Panther weapons actually came from police weapons. So during this period of time, we are also dealing with Bill Bender, with Arthur Kanoy and Bill Goodman in Detroit in trying to figure out how to bring what would turn out to be a massive federal civil rights lawsuit under Section 1983. And we were totally, not only were we young lawyers and law students, but we were totally green about using Section 1983. And so in June, we filed several voluminous complaints on behalf of the survivors of the raid, and also the families of Fred Hampton and Mark Clark. And that became the vehicle that facilitated over the next 13 years, not only uncovering a wealth of evidence about FBI conspiracy, but also in continuing to change the narrative from a shootout to a shoot-in to a murder to a political assassination. And I think that's where we stand here today. And I'll turn it back over to whoever's picking up the baton from where I dropped it.
Yeah, no, thank you, Flynn. Of course, there were so many turns and bumps along the way in this litigation. You filed that lawsuit, and the trial judge granted a motion to dismiss on behalf of State's Attorney Hanrahan and actually all of the other defendants except for the officers who participated in the raid. And I know, Bill, that issue was one that you intended to talk about.
Well, the challenge from the beginning was how to hold Hanrahan and his associate, the state's attorney and the deputy, responsible for the raid. You know, although there was surmise in the early stages that there may have been federal involvement, we really had no facts at that point to bring in the federal defendants. But we did have the facts to bring in Hanrahan and Jelinek. So the challenge was how to get the courts to let us sue a prosecuting attorney for what amounts to police misconduct. As Flint mentioned, the district court dismissed the complaint against the state's attorney. We took an appeal to the Seventh Circuit, argued it before a judge whose name will be familiar, Circuit Judge then John Paul Stevens, who became Supreme Court Justice Stevens. And we argued that when a prosecutor acts like a policeman, he loses the cloak of quasi-judicial immunity, and he can be sued as can be any other policeman. So we argued the case to the Seventh Circuit. We had the benefit of a courageous Justice Stevens, then Judge Stevens, who ruled in our favor, and the case was reversed and remanded, and we were allowed to go forward with discovery to pursue that theory, and also to have the vehicle to gather additional evidence relative to the possible federal role. So that was a win. We had the fun of briefing that case at the U.S. Supreme Court with Rutgers law students, and the court denied cert. And there we were with a fresh lawsuit to start doing what lawyers do, and that is probe the facts. Right, Flint? So probe the facts. We did.
And Flint, one of the things you've mentioned in our preparation was that there was this community support to help sustain the PLO in the course of this ongoing, now already halfway through the marathon, I think maybe at this point.
Yes, after the case came back, we're in 1972 now, so we're really still very early on in this remarkable odyssey. The government revealed that a Panther member and one who had access to Fred Hampton and the apartment was in fact an FBI informant provocateur. And his name was William O'Neill. And of course, we were all shocked. O'Neill was, like many of the other Panthers, a client of ours, but he was revealed. And so we, together with Bill and the Rutgers folks, started to embark on discovery of what, in fact, O'Neill had to do with the raid. And early on in 1973, we made a discovery demand, a Rule 34 demand, and that floor plan, which has been on the screen previously, was turned over by a nervous U.S. attorney who didn't want to be involved in a massive cover-up. Now, this floor plan was drawn by O'Neill. This floor plan was given to his control agent, Roy Martin Mitchell, who was a point man for the FBI's focus on and move to disrupt and destroy the Panthers in Chicago. And as you can see, this floor plan depicts room of Hampton and Johnson when they stay there, and points to the room, and there's the bed where we see the bloody blood of Fred Hampton on the morning of December 4th. And this floor plan Mitchell took to the state's attorney, Hanrahan, and who had the 14 police officers who were personally assigned to Hanrahan to prosecute. And this floor plan then became the basis of the raid on the apartment. This was all kept secret by the FBI for several years until it came out in this unrelated case. And the documents were turned over to us after we came back from the first appeal. And that led us to depose O'Neill on two occasions. Bill participated in the first deposition. We deposed Mitchell, we deposed the head of the FBI here in Chicago, and we joined the FBI, the local FBI defendants, including O'Neill and the others, in the conspiracy in the lawsuit. And so that takes us into Watergate times and the post-Watergate and the Senator Church Committee's investigation, which was going on in a parallel way to the investigation that we were doing in the Hampton lawsuit. And I'll stop and catch a breath here and let other people pick up where I left off.
Great. So then, with all this discovery, you nevertheless wound up with another unsatisfactory ruling from the trial court and back to the Seventh Circuit again, right, Bill?
Yeah, and this appeal was done by the PLO, unlike the first appeal where we participated in it. So I can toot their horn for a minute. An 18-month trial, 37,000 pages of transcripts, a palpably hostile federal district judge who gave them grief at every turn, a federal government that persisted in hiding evidence throughout the trial, two lawyers, including Flint, held in contempt, a defense team that was being paid royally by the city and the county for their work, and a PLO that was financing this with a wing of prayer and community support. And at the end of the day, remarkably, this judge directed a verdict of acquittal for all the defendants except the individual raiders, setting this case up for what became one of the most remarkable appeals in the civil rights lexicon I've ever seen. If your students read anything about this case, they should go to 600 F. Second 600 and read the 89-page decision authored by Judge Spiker. So, Flint, can you give us a sense of what this trial was like and how you guys put this appeal together?
Oh my God. I like to tell young students that, hey, my first trial was 18 months long. And I spent some time in the federal lockup during that 18 months. The run up to the trial, we were getting information that the COINTELPRO program and Hoover's pet project to destroy Black nationalist organizations and their leaders was behind the raid in Chicago. That not only were the locals supplying a floor plan, but it was part of a grander COINTELPRO project of the FBI. And so we were madly raising this issue and trying to get more evidence. And the judge, who was kind of a meaner version of Julius Hoffman, the judge in the conspiracy trial, was blocking us at every point. But early in the trial, this FBI agent, Mitchell, was on the stand, and he inadvertently made the mistake of revealing that there, in all likelihood, were documents that had been suppressed during discovery. And when we raised heck about that, the judge, not knowing what he was doing, said, "Oh, all right, bring those documents up." And a panicked U.S. attorney from Washington thought, I don't want my ticket to go on the line here. And lo and behold, the next day they presented to the court and to us 200 volumes of FBI documents that had been suppressed. Well, the judge let them redact those documents. And over the next 3 months, while we were continuing this trial, we were also getting redacted volumes. And so it wasn't until the 200th volume was turned over that we got what was known as the bonus document. And I like to say there was a trilogy of documentation that showed that unlike the assassination of Dr. King and the assassination of Malcolm X, which were definitely things that the FBI wanted to have happen, that in the Hampton case, they were involved and the moving force in making it happen under COINTELPRO. And the first document is that floor plan you saw. The second document was a COINTELPRO document dated the day before the raid, which predicted the raid and said it was a part of the COINTELPRO program. And the third document was this bonus document. And the bonus document showed that O'Neill, the informant, had gotten $300 bonus, his 30 pieces of silver, for making and setting up the raid, which was, quote, a success, according to the FBI, and that his information was, quote, of tremendous value that could not be obtained by any other source. So that was the trilogy of the assassination documents that we presented during this 18-month trial. However, the judge was determined that we weren't going to be able to go to the jury on either the FBI conspiracy or on the conspiracy of the shooters who fired the 90 shots, 2 of which were fired at point blank range into Fred Hampton's head. So he threw it all out after 18 months. And I have to say, as the lawyer who ended up reading 37,000 pages of transcripts, that was quite a task. But we were able to marshal that evidence, file a 250-page brief, and after a day of arguments, we were fortunate enough, like we were to get Justice Stevens back in the first appeal, to get Justice Swigert or Judge Swigert on our panel. We got a second liberal judge, Judge Fairchild, and then the third judge was a former FBI agent named Wilbur Pell. So we won 2-1. And that opinion, which I like to tell law students, and I'm so glad you gave the site, Bill, don't tell anyone, but sometimes versions of that become my password in various places. It's a marvelous decision. It's just you don't read a decision that outlines a government conspiracy to assassinate and cover up every day in the law books. And so that led to the defendants taking it to the Supreme Court. We persevered. Cert was denied as to the feds on a 5-3 vote. Stevens had to recuse himself because now he's on the Supreme Court. 7-1 denied cert on the conspiracy by the police officers in Hanrahan. And then we came back and reluctantly, after getting another judge and moving towards a hearing on the government misconduct and other misconduct by the state's attorney, we entered into what was at that time the largest civil rights or police brutality settlement of its time. But as Mrs. Hampton, Fred's mother, who was a staunch soldier who stood with us along with Mrs. Clark and Bill Hampton through the entire litigation, sat in court every day for 18 months and heard her son slandered and all the lies that the defense put on. As Mrs. Hampton said, no one went to prison, no one went to jail. So it wasn't a complete victory. But on the other hand, we had come a long way in changing the narrative. And as a people's lawyer, I like to think, and I'm sure Holly and Bill will agree with this, that not only do we litigate and try cases, but we also use the mechanism of the cases to discover evidence, particularly in big government misconduct cases such as this. And then we have an obligation to make as much as we can of that information public and to educate and talk about it. And I feel that it's an obligation of mine to not only write about the history, but to talk about the history, particularly to young law students and students who may be trying to figure out exactly where they want to put their lives in terms of becoming lawyers or activists.
Thank you so much for that, Flint. It is. I hope we have lots of students watching, and that's just a remarkable story every time I hear it. We're actually going to have some time for questions, but before we do that, we actually have our fourth speaker who's going to help orient us to the here and now, to Seattle and to this moment. And as we pivot to Seattle, I happened to stumble across, as we were preparing for this headline from 1970, February 1970 in the New York Times, in which it says that Seattle Mayor Wes Ullman had been approached by the FBI to have a raid on the Panthers here. And he had demurred. He said no. For a little bit of, if you take him at his word, a little bit of principle, a little bit of pragmatism. But regardless, it's clear that no raid happened. So just a little bit of history that I was certainly unaware of before getting ready for this. But now I want to bring us to the present day of Seattle and to invite LaRon Baker to come in and talk about the work that she's been doing on police accountability, both through her position at DPD and with the Seattle Community Police Commission. So LaRon, please take the floor.
Great. Thank you. Good afternoon, everyone. I hope you can hear me. I just had a little bit of a technical issue, but I presume you can. I'm LaRon Baker, and I'm Special Counsel for Affirmative Litigation and Policy with the King County Department of Public Defense. I also am recently a co-chair of the City of Seattle Community Police Commission. And I'm really honored to be part of this panel. The amazing work that has been talked about is deeply inspiring. And I'm here to talk just about the sliver of police accountability work that I have been able to work on with community members and with other legal advocates and community advocates here in Seattle. And it's just a sliver of the accountability work here. You know, as we've seen in the last year, there have been really extensive community-based movements that exist outside of legal practitioners and or are assisted by legal practitioners that are doing substantial work. So I've got sort of two bodies that I'd like to talk about. One In my role at DPD, or the Department of Public Defense, I actually oversee and represent families in inquest proceedings. So it's similar to the inquest proceedings that were talked about earlier, the county inquest or the people's inquest. King County has long had an inquest process where when an individual is killed by law enforcement officers, there is a public sort of fact-finding or inquest that happens. And for many years, community members were deeply dissatisfied by the process. They didn't feel like it allowed for enough of a public investigation or discussion about what happened, or that some of the information regarding the use of deadly force just wasn't thorough enough to satisfy community members' interest in finding out what happened in one particular case, and also just in knowing how law enforcement is investigating other law enforcement agencies or use of deadly force. Community activists came together, a whole range of community activists, primarily activists of color, came together and advocated for a change to the inquest process to more meaningfully involve the families who've lost loved ones to police violence, and to assure that there's real transparency and public ability to view these inquests, view the witnesses who've been questioned regarding a use of deadly force, be able to see some of the evidence, that the inquest be a public fact-finding or more public than it had been. King County Executive Dow Constantine, heard those the pleas of impacted communities, primarily communities of color, and changed the process. And right now, we are sort of getting that process stood up. Inquests have just started underneath this new procedures where families are represented by attorneys, and those attorneys are housed in the King County Department of Public Defense unless families are able to find their own. So you have public defenders who are, representing the families to make sure that the investigation of the use of deadly force is thorough, answers the family questions, and is able to present all of the information to the community. And that's incredibly important because many of the individuals who die from law enforcement officers' use of deadly force either have been our clients, like as in the case of Charlene Lyles, or would have been our clients had they managed to survive the incident. So in my role, I am an attorney for the family of Damaris Butts. And his death, the inquest into his death, is the first one that's happening under these new, more expansive rules. And there are 3 cases that are currently moving forward. They are pending right now because their processes and procedures are sort of stayed until the Supreme Court rules on lawsuits that the families brought seeking to require officers to have to testify about their use of deadly force, and also lawsuits that the family brought to allow the jury to consider whether or not criminal conduct occurred when the use of deadly force. Law enforcement agencies filed their own lawsuits seeking to get rid of the process entirely, more or less arguing to some extent that there doesn't need to be a public vetting or airing of officers' use of deadly force, even though community members really want to know. Families want to know what happened and want to be able to test the evidence around the death of their loved one. And the community has expressed significant interest in being able to have really thorough discussions about how the power that we place in law enforcement's hands is being used, and is being used more often in cases against community members of color. So we're waiting for that to resolve itself. But in my role, I represent families and I also oversee the inquest process in and of its entirety within DPD. So getting that stood up, and community members have come forward really strongly to support our process. Throughout the litigation that's moved forward, we had amicus briefs that were signed by 30 plus community organizations that range from your traditional legal organizations to really hands on the ground advocates for criminal legal reform. And it's been great working with those community organizations to be able to have their voices heard in places where they may not always be heard. And obviously the work that the Department of Public Defense does, public defense is just such a critical key actor in ensuring that we move forward in a racially just and equitable way in our society. The criminal legal system really, as we all know, targets and harms and it impacts people of color and community colors really at extended rates compared to white counterparts. And public defenders are just the key point in being able to provide protections for those populations within the criminal legal system, and also to afford constitutional protections, especially in this moment of ever-changing times when it comes to technology and technological approaches that law enforcement may have when it comes to encroachments on our privacy rights. My work as co-chair of the Seattle Community Police Commission has actually just recently started. I became a co-chair in mid-January, but the CPC has been around for years. It sort of got its origins in 2010 when about 35 different community organizations wrote to the Department of Justice demanding that there be an investigation into what was a very disturbing multiple months of local law enforcement's use of deadly force against primarily people of color, including John T. Williams, who was a native woodcarver in Seattle that was well known and whose death was really incredibly tragic. The Department of Justice came in, sued the City of Seattle, and after a decade down the line, we are still sort of in a consent decree, a settlement agreement that requires the City of Seattle and Seattle Police Department to comply with particular policy and practices, trainings to protect against excessive use of force and bias in policing. I feel like I might be running out of time, so I'm going to try to move this quickly. So the Seattle Police Commission, Community Police Commission, is tasked with ensuring that Seattle community members' interest and thoughts are able to be presented when it comes to policies, practices of the Seattle Police Department. Recently, the Seattle Police Department issued new use of force policies, and the CPC held community meetings to get feedback from community, and specifically most impacted communities, about those particular uses of force policies and what community members actually wanted to see in order to make them feel safe while being protected by law enforcement and safe from law enforcement. And we put forward those proposals to the Seattle Police Department, and we are now in a discussion back and forth about when and how and what parts of our recommendations or the community's recommendations Seattle Police Department may take into consideration with these new use of force policies. We also have recently provided, we held community forums to provide input into what the public wanted to see and did not want to see in law enforcement's contracts moving forward as we go through the current collective bargaining process. The Seattle Community Police Department also holds multiple community events where we provide know your rights information to community members and specifically really try to reach out and ensure that those who have been most impacted have their voice heard at the decision-making tables when it comes to policies and practices that impact them. Thank you.
Thank you, Laron. And that puts a great cap on these presentations in terms of the variety of ways that lawyers can impact and work with community and advance community objectives around these critical issues. So I thank you. I want to thank all of our speakers for sharing your wisdom and your experience. And now is the time to invite questions from any of our audience. If you just want to send them in the chat, I will try to manage that and get them to our experts here. So anybody who has one, please just fire away, and we will spend a few minutes further with this amazing group of people. Not seeing anything popping up just yet. Maybe it's a little slow. I have a question for you, Flint. You know, PLO, of course, is a highly unconventional business model, shall we say? What would you say to students about if they want to be like you, they want to do this work? How do they do it and feed themselves and take care of the rest of life? What advice do you have?
Well, Holly can chime in on this as well. It certainly is hard from time to time financially, particularly for those who have loans, although hopefully most of those will be forgiven in the near future. But all I try to say is that as much as possible, you need to stay committed to your beliefs and to look for whatever you are inspired by in terms of the kind of movement or public interest work that inspires you, and to make every effort that you can to go into that kind of work. I know it's hard financially, and we had our moments where we didn't know whether we would survive or not, but somehow we're still standing 51 years later. And it's hard. I wouldn't necessarily promote our particular business model, although it's worked. But obviously are personal sacrifices that you make. Sometimes they're easier to make when you're younger and don't have a family, than when you get older. So I would say that don't pass up on opportunities when you're young, if at all possible, to pursue what you want to do, so that you won't be looking back 10 years later and wonder why that law firm that you went into because you thought you had to is representing polluters or is representing killer cops or whatever the case may be. I can't give you a blueprint, but maybe Bill and Holly can give you a little more specific feel for how to do that in a way that may not be quite the same as starting a people's law office.
Yeah, so Bill, that is an interesting one to throw to you. Of course, you came here and you were a federal defender for a number of years, and then went into private practice, but yet have carried forward on those values that animated you back when you were at CCR. Maybe you want to talk a little bit about that.
Well, I joined a law firm that was formed in the height of the Depression, and had then a wonderful commitment to doing public pro bono work. And I think that's been a hallmark of our firm all the way through. The firm made huge commitments over the years on some very large impact litigation, including litigation we're continuing with to this day. So I think, as Flint says, it becomes a matter of choice. And you need the right group of people who are motivated to do other things besides making the maximum amount of money as practicing lawyers possible. And with that caveat, there are a lot of variations on the theme. The large firms do pro bono as a way to educate their young lawyers. And we have some firms in Seattle which have made, some of the major firms in Seattle, which have made huge pro bono commitments over the years. There are other firms like ours. I think I saw Kay Frank on the video here someplace a few minutes ago, which have built that component into their practice. And it becomes a function of who the individuals are, their commitments to the values that they share with their colleagues, and their willingness to make choices.
And Holly, you of course ended up taking the bench, and I wonder sort of what motivated that and how that sort of put a cap on your career.
Oh, well, I'll answer that question, but I also just wanted to add, I want to reiterate something Flint said, that you have to be ready to be hungry, if you want to hang up a shingle as a young lawyer and try to do civil rights work. So the other part of that Bill alluded to is it's so important to have a team that you really trust and that you have mutual caring, because it is hard. And the People's Law Office had, lots of internal conflicts with the people with each other over the years, but at the same time, there always was a constant belief that we were doing work that was very important, everybody had the same, pretty much the same sense of what was important work. You know, we had this very similar belief systems. Maybe Flint would agree or disagree with that, but I think finding those people who you agree with about what is important and who you agree with about willingness to, you know, maybe be hungry or, you know, or stick your neck out is really important. But my decision to go on the bench wasn't exactly it wasn't so much tied to the work that I had done as a lawyer. I did, when I moved out to Seattle, worked in the public defender and worked in the Equal Employment Opportunity Commission doing pattern and practice discrimination cases. Being an advocate is very different from being a judge, obviously very, very different roles. As an advocate, you can, you know, pursue what you believe in. If you design your career and make those choices, that's what you want to do. As a judge, and then some of the time, in order to you know, to put bread on the table, you may be doing work that isn't directly related to your passion. Of course, as a judge, I felt privileged to go to work every day and feel like what I was called upon to do was to do the right thing every single day. But the downside of that was that meant to apply the law, and applying the law in a system that is unjust. Sometimes you're the instrument of that. So I saw Bob Berukowitz on the call, who's everyone probably knows works at is teaching at SU now, but was our public defender. And I remember speaking to him about why he didn't go on the bench, and he said, "I don't want to send people of color to prison every Friday," which is sentencing day. So it's a mixed bag, but I did feel as a judge that I was called upon to enforce the law, and much of that was I also agreed was doing the right thing. Anyway, I don't know if that makes sense, but I hope I'm answering your question.
Thank you, Holly. We have a question which would be for Laurent from Monica Mendoza Castrejon, wanting to know about other examples. She references your discussion about the inquest, but wanted to know about sort of other sort of arenas, I would say, where you see this, maybe the battle of the narrative in Seattle around criminal legal reform, as you described. What are the things that are happening that folks might want to be paying attention to?
Yeah, I think one of, from my personal opinion, one of the areas where you're seeing this really sort of tense battle of the narratives actually is around the consent decree litigation that consent decree litigation that I referenced earlier, which is where the Community Police Commission got its origin. Early last year, just before, I want to say it was in April, maybe May, so right before the Black Lives Matters uprising, the city of Seattle, the Seattle Police Department moved to actually come out from underneath the consent decree or the sustainment plan, essentially arguing that it had, got all of its everything in order, and it had really remedied the issues of excessive force and bias that might have actually been the reason for for DOJ coming in, doing an investigation, the findings, and ultimately the entry of the consent decree. As we all know, especially those of us who live in Seattle, what the Seattle Police Department did last summer really showed that it had a long way to go before it was fully in compliance with community expectations around how use of force would be used, and potentially even legally how use of force should be used against community members, which was why Judge Jones issued a temporary restraining order against some uses of crowd control weapons. So now, ultimately, after a lot of public pressure in the face of so many community protests around SPD's actions, the city withdrew that request. But ultimately, is still, putting forward in some ways a narrative that it has, either, complied with the consent decree, is ready to move on, is able to sort of self-police itself when it comes to excessive force, while you have activists who are on the ground decrying on a daily basis as protests come forward what they say are, extreme uses of force against protesters, against bystanders, against people walking down the street. So there's a real tension there, I think. And that's coming into play when it comes to questions around police funding, right? In Seattle, there's this great movement, I think it's great, movement asking for the defunding or, limiting funds for the Seattle Police Department and moving some services from the police department into maybe entities that might be more appropriately situated to handle mental health crises, for example. But the city of Seattle both, seems to be saying it doesn't need to be part of the consent decree, but then also says the consent decree keeps them from making any major substantive changes that might be in line with what some of the community activists are wanting. So I think that may be a place that I personally see a lot of the battle of the narratives happening right now. There also are concerns about prosecutorial discretion. We have prosecutors who are really making some pretty significant changes to how they prosecute, what they prosecute, but then also on the other hand, maybe pushing back really substantially on reforms that have been put forward legislatively or through judicial opinions that have come down that seek to roll back protections that community believes are appropriate for within the criminal legal system, which is another area.
Right, and I would just take the moderator's prerogative for a moment to add on, to pick up on that note, and with Justice Gordon MacLeod here to reference the Blake opinion, which has transformed the way in which Washington State's criminal legal system addresses the possession of controlled substances, and that will be no doubt an arena in which there will be lots of vigorous debate over the coming years as we figure out what to do. One question in the queue, and I have to ask this when it comes, and I have to acknowledge the contributor as well, comes from Kate Cohn, who graduated from our law school and was the student speaker at our December graduation, and to our panelists might be interested to know, is the daughter of Frederick Cohn, who was representing Fred Hampton on appeal at the time of his death. And she asks about, or makes reference to her knowledge of the John Burge being the commander of the Chicago Police Department who led the torture program that Flint writes about in his book. And when we say torture, by the way, that is not a loose or in any way sort of metaphorical interest. And for folks who don't know about that history, just look it up. It is torture pure and simple in the most naked way. But anyway, as a result of that work, there's now the instruction on that. Students in the Chicago Public Schools, Kate references, are taught about John Burge, and she wonders whether there's any momentum perhaps arising out of the fact that there is this attention from the film, or otherwise to perhaps get Fred Hampton's name or otherwise sort of bring this perspective on what happened to the broader audience in Chicago specifically, and then maybe as a way of sort of going further. So Flint, any perspective on that?
Well, first, let me say that Fred Cohn was my lawyer when I was subpoenaed to testify in the Hanrahan trial. I love Fred Cohn, and it's such a small world to meet you, Kate, and we should get in touch with each other because Fred was one of the people that we went to because he was known as one of the greatest appellate lawyers, criminal appellate lawyers in the city, and one of the few appellate criminal lawyers who was down with the Panthers and down with the politics that the Panthers believed in. Wow, small world, as they say. Yes, the Burge struggle led to reparations, and a major portion of the reparations was that the Chicago Public School was and teaches a section every spring on the truth about the police torture scandal. And again, I like to talk about how we were involved in helping to change the narrative in the Burge torture cases over a 30-year struggle. And that's a lot about what my book is about. It would be very important if the true Fred Hampton story was taught in the schools. And we now have a popular Hollywood movie, but I would suggest that anyone, and I would say that it's rewarding in some degree to see a lot of that 18-month trial in terms of the evidence being reenacted in a movie. But if you want to really see about the Fred Hampton case on film, you want to see Mike Gray's movie, The Murder of Fred Hampton, a black and white that was made right after Fred was murdered. And you want to look at Eyes on the Prize 2, which came out in 1990, which brought it up to date with the FBI role. And there's a movie called American Revolution 2, which was made by Mike Gray and talks about the Rainbow Coalition between all of the organizations in Chicago, was spearheaded by the Panthers and Fred Hampton. I don't think at this point there is a movement to teach the Fred Hampton story in a unified way, the way that reparations is being, through reparations, it's being, the Burge story is being taught. But I think it's that, and the idea that there's still more to learn about the case. Most recently, we came across some files that showed that Hoover and his people in Washington were in fact on top of the Hampton assassination, and gave Mitchell a reward, a bonus similar to the one that O'Neill got. Holly knows that we went together to Washington to depose William Sullivan, who was second in command under Hoover, and the others who, it turns out, were intimately involved according to these new documents. And we asked the right questions, but the government wouldn't let them answer back in 1975. And now we have documentation as to Hoover's role, and as well as the documentation that we got during the litigation. So the education and the narrative continues to be built. And I think it's important for us who deal with the narrative, if we don't stay on top of it, and we don't continue to talk about it in the way that of truth-telling, that those in power and those who have a reason to distort and lie about it will going to reinvent their narrative. So that's why it's important not only to get out the information, but it's important to write about it and talk about it and to educate about it. And as youngsters then and as elders now, I think that I have great respect and admiration for young folks who are fighting the battles, particularly in the movement for Black lives, and the students fighting against guns in schools and all of that. But the youngsters have to listen to us from time to time, because we have some history. We have some knowledge about not only what we did right, but what we did wrong. And so hopefully the movement would take up the idea of educating not only in Chicago, but across the country in a unified way, the torture, not the torture, the assassination of Fred Hampton.
All right.
I wanted to add,
Holly, please, yes.
I heard an interview of one of the two directors of Judas and the Black Messiah, in which he said that he had learned of Fred Hampton at school. He had learned about Fred Hampton at school. I don't know where this was, but it was interesting to me because he referred to it kind of as ancient history, and I realized that for a young person it is ancient history, but that he was motivated to make the film because he wanted to explore what he had heard in school about Fred Hampton. And I think that Flint is absolutely right in what he's saying at a time when there is finally a recognition of the systemic nature of these things. This is part of the narrative that is very powerful in explaining that across our society and relating it to what's happening today.
Great. Great, perfect. So thank you again. So all of you, our speakers, so very much for just a remarkably informative and inspiring talk. I feel fortunate to have had the chance to spend this 90 minutes with you. So thank you all. And I'm going to send us out with a recording, which I discovered only recently, that the Panthers had a house band called the Lumpin', an in-house revolutionary funk band. And I'm going to try, if I get this teed up right, to play some of their music as we leave. So here it goes. Free Bobby now.